I was invited to give you a taste of a typical law school classroom experience here today, and I thought I would take advantage of this opportunity to do something that's been on my mind for a while. To stand up and to proudly say, God bless America, God bless the Bill of Rights, and thank God for the Fifth Amendment. I'm not ashamed to say I'm proud of the Fifth Amendment, and I'm proud to admit on camera and on the internet that I will never talk to any police officer under any circumstances, with all due respect, sir. I'm doing something really extraordinary here today, something you'll almost never see another law professor do as long as you live. I'm really putting myself on the spot here. This was my idea. By my invitation, I have given up half of my time, approximately. I'm giving equal time and the last word to an expert who really knows something about what I'll be talking about. So I'm opening myself up to the possibility that he will contradict me. I was a criminal defense attorney when I was in private practice. So I want to make sure, in fairness to you, if I'm misleading you or giving you a slanted or one-sided presentation, you'll be able to get the last word from somebody else. I'm sure he'll have a lot to teach all of us, including myself. The Fifth Amendment to the United States Constitution provides, no person shall be compelled in any criminal case to be a witness against himself. And this unfortunate amendment has gotten a bad rap in recent times, much of it tragically and unnecessarily through, as you may have heard, the headlines. There was a recent Regent Law School graduate who was in all the news for a couple of weeks. She was an outstanding former student of mine, and she really got quite a lot of undeserved flack for the fact that she chose to exercise her right to remain silent when the Senate wanted to ask her certain questions that arguably might have tended to incriminate her. All of the world was aghast. The Christian community in particular looked at this and said, how could a Christian do such a thing? How could a Christian take the Fifth Amendment? And I said, you go, girlfriend. I do the same thing. I'll do it every time. And I want to talk to you about why that's true, but first a quick listening test. Let me read you something that was taken out of the newspaper this morning, and I want you to listen to it closely. And I'm giving you a heads up. I'm warning you in advance, which is not fair to you. Not fair to me, but I'm giving you a warning that I'll be quizzing you on this in just a few minutes. This will test your aptitude for legal study and legal practice. Listen closely, it won't take long. Last night, agents of the Norfolk Police Department found 3 victims of an apparent murder dead in an apartment in the East Ocean View area. The apparent victims of a gangland-style slaying, and possibly the victims of gang-related violence. The police are investigating this as a possible murder and suicide, but right now suspect that the 3 were all killed by the same individual. No suspects have yet been identified in the slaying, but veteran police detective George Brook has confirmed that police are following up on evidence pointing to the possible involvement of an off-duty naval officer as the perpetrator. The bodies, which were found by the apartment manager at about 8 o'clock in the morning, appear to have been slain sometime earlier in the same evening, probably sometime between midnight and 2 o'clock in the morning. That's it. Those are all the facts I'll ask you to remember, and it won't be for very long either. Let's see how well you do. I'll be quizzing you in just a few minutes. Now, here's the easiest question you'll ever get from a client in all the days of your life. Question, hey, the police are here. They want to talk to me. What should I do? Well, I could give you my answer to that question in case you haven't already guessed it, but why don't we go to a real expert? Justice Robert Jackson, a prosecutor's prosecutor. Like me, he began his private practice in Buffalo, New York, years before I did. And after that, he served as general counsel for the Bureau of Internal Revenue, the U.S. Department of Treasury, the Security and Exchange Commission, Assistant U.S. Attorney General for the Tax Division, later the Solicitor General and the Attorney General of the United States, and then the Chief U.S. Prosecutor for the Nuremberg trials. That's an impressive resume. Years later, when he was a justice on the Supreme Court, Justice Jackson stated, quote, any lawyer worth his salt, today we would say his or her, will tell the suspect, his client, in no uncertain terms to make no statement to the police under any circumstances. There's the title of my talk. I'm here to explain to you the surprising and somewhat counterintuitive and admittedly unlikely reasons why Justice Jackson was right. I'm reminded of this because I'm amazed. We're all amazed by the frequency with which we see newspaper articles coming out all the time from people who really ought to know better, who say, well, I'll talk to the police. I mean, after all, I'm a senator. I'm O.J. Simpson. I'm an experienced, highly polished individual. I've got a lot of experience with public relations, even criminal defense attorneys. There was a local news story here in the Virginia Pilot just a couple of months ago about an experienced criminal defense lawyer who ended up getting convicted of criminal assault because he talked to the police. He was accused of having assaulted another attorney in the hallway. There were no other witnesses to this. A woman said that he grabbed her by the throat during an argument over a case. He denied it. At trial, it was his word against hers. He said, I did not even touch her. But unfortunately for him, when the police had approached him earlier and said, would you be willing to answer some questions? He said, sure, why not? I'm an attorney. I'm a criminal defense attorney. I'm savvy. I'm sophisticated. I've got oratorical prowess. I'm accustomed to dealing with the police, by all means. And then there was a conversation that was not recorded. When the case went to trial, It was no longer his word against hers, because when he testified at trial, I never touched her. The officer took her to the stand and testified, well, when I met with him, he said he did put his hand on her throat, but just as a joke. Then he had to take the stand again and say, that's not true. I never said that. I never admitted to you that now it's his word against two people. Who's telling the truth? We'll never know for sure. But he was found guilty. Now, here's part of the problem. The heart of the problem, as Justice Breyer on the U.S. Supreme Court explained in 1998, is, quote, the complexity of modern federal criminal law codified in several thousand sections of the United States Code and the virtually infinite variety of factual circumstances that might trigger an investigation into a possible violation of the law make it difficult for anyone to know in advance just when a particular set of statements might later appear to a prosecutor to be relevant to some investigation. One expert on criminal law recently noted that estimates of the current size of the body of federal criminal law vary, although it has been reported that the Congressional Research Service can no longer even count the current number of federal crimes. That's right, even the federal government has lost count. These laws are scattered over all 50 pages of the U.S. Code, encompassing roughly 27,000 pages. Worse yet, these statutes often incorporate by reference to the provisions of administrative regulations. Estimates of how many such regulations exist are even less well settled, although the ABA thinks there may be nearly 10,000. Here's one of those 10,000 federal criminal statutes on the book that you probably never heard about. It's called the Lacey Act. 16 U.S.C. Section 3370 says it's a federal offense for any person to import, export, transport, sell, receive, acquire, or purchase any fish or wildlife or plant taken, possessed, transported, or sold in the violation of any law, treaty, or regulation of the United States or any Indian tribal law or any state or any foreign law. People have been convicted in federal court for violating this statute because they brought back a bony fish from Honduras, not knowing that Honduran law, not American, but Honduran law, forbade the possession of the bony fish. People have been convicted under this law because they were found in possession of what's called a short lobster, a lobster that's under a certain size. Some states forbid you from possessing a lobster if he's under a certain length. It doesn't matter if he's dead or alive. It doesn't matter if you killed it or if you died of natural causes. It doesn't even matter if you acted in self-defense. Did you know that? Did you know it could be a federal offense to be in possession of a lobster? Admit it. Raise your hand if you did not know that. There's the problem. And that's only one of 10,000 different ways. You know, the government gets pretty upset when people like me instructs the client, people like me and Justice Jackson, don't talk to the police, don't answer any questions. But you know, they can't have it both ways. You people, you've got 10,000 different ways of convicting us. Good for you, but you know, with the bitter comes to the sweet, with the good comes to the bad. That's 10,000 different ways my client might unknowingly implicate himself in some sort of a criminal transaction. One of the reasons I decided to give this talk, I recently received a phone call from a former student of mine, a Regent Law School graduate, who may be watching this online. We're putting it on the internet. And he told me, hey, I've been approached by the Internal Revenue Service. They want to ask me a couple of questions. They ask if I'd be willing to. But they say that I'm not a suspect. And I know in my heart I don't think I've done anything wrong in violation of the Internal Revenue Service provisions. Lord have mercy. There's no man on earth, there's no woman in this country who can honestly say with complete confidence, I know I have never violated any provision of the Internal Revenue Code. He said, but they say I'm not a suspect and I know I've done nothing wrong. It's okay if I talk to him? I said, no, you tell them you will not talk to them without immunity. I explained to him why that was true, and he never heard from them again. Okay, why you should never talk to the police. Let me just spell it out for you. Let me make it plain to all of you. These are the top 10 reasons. I shouldn't really lie to you. I don't really have 10. I don't have time for 10, but I've got time for 8, and that'll be close enough. Number 1, and this really ought to be good enough. Contrary to what you laymen instinctively and naturally suppose, it cannot help. There is no way it can help you. Plenty of folks think that it can, and they're always wrong. You cannot talk your way out of getting arrested. Officer Brook, you've interviewed thousands of criminal suspects. Have you ever, how many times in your experience, have you approached someone, asked if you could ask him some questions because prior to the interview you had some evidence pointing to his possible guilt? And because of the extraordinary persuasiveness and eloquence with which he articulated his innocence, you said, oh, sorry, never mind. Bad call, my bad, I won't. And he talked you out of arresting him.
You know the answer to that.
Never. Never. It never happens. I've often asked other criminal defense attorneys, in all of your experience, have you ever once had a case where you looked back in hindsight and said, thank God my client talked to the police? They laugh at me. They laugh at me. They say, you've got to be kidding me. You cannot help you. You can't talk your way out of getting arrested. And contrary to what you might suppose if you never studied the rules of evidence, what you tell the police, even if it's exculpatory, cannot be used to help you at trial. Because it's what we call hearsay. Under the rules of evidence, specifically Rule 801D2A, if you want to look it up, everything you tell the police, as the saying goes, can and will be used against you, but it cannot be used for you. From time to time, I've known attorneys who tried to call to the stand a police officer and say, officer, would you tell the jury what my client told you because what my client told him is actually good for my case? If you tried that at trial, the prosecutor will object that it's hearsay, and the judge will agree. The police will not be allowed, at your request, to tell the jury what your client told him, no matter how good it may be for your case. It cannot help. And that ought to be good enough reason. That ought to be reason enough to keep your mouth shut. But if you're not persuaded, let me go talk about a couple of others. Number two, obviously one of the most obvious. If your client is guilty, as many of them are, but even if he's not, even if he's innocent, he may well admit his guilt with no benefit in return. Now, of course, many of you are thinking to yourself, well, what's so wrong about that? I mean, shouldn't guilty people be confessing? Confession's good for the soul. It's good for law enforcement. It's good for the prisons. Yes, sure, all those things are true. And like the rest of you, if I or anyone close to me is ever the victim of some sort of a serious crime, I hope they get the right guy. I hope they convict him. I hope they put him away. We all feel that way. Hey, but what's the rush, friends? You don't got to admit your guilt the first time they come by to meet with you. In federal court, 86% of all defendants plead guilty at some point before trial. If your client is guilty and really ought to punish and really ought to have go through some sort of a cleansing act of contrition and fess up and admit his guilt, there'll be plenty of time to do that. They almost always do. No need to rush, no need to tell the police something. Wait and see if perhaps your client can work out some sort of an arrangement where maybe he'll make some sort of compensation to the alleged victim, or maybe he'll be able to get some sort of a discount in his sentence. And he'll be treated fairly then, like everybody else who had the benefit of a good lawyer who said, please do not talk to the police. And don't forget, by the way, even if your client only admits to things that the police already knew, you might think, well, what harm can it do? He says he wants to talk to the police. All he wants to do is admit that he was there, but the cops know that he was there. All right, go ahead and tell him. Well, how can it hurt? It might hurt if the police officer becomes transferred to Minnesota, or deceased, or injured, or comatose, or cannot be located by the time of trial. The case will be dismissed if there's no confession. But if your client admits to things, that confession is freely admissible against him and can be a basis for getting him convicted all by himself. Senator Larry Craig can explain all of this to you. The Innocence Project of the United States has confirmed that in more than 25% of all the cases where an innocent man was convicted and then later released from prison after he was exonerated by DNA evidence, in more than a quarter of those cases, these innocent people we know to be innocent, made incriminating statements, delivered outright confessions, or pled guilty. How do they do that? He'll tell us all about it, I trust. Here's a couple of famous examples. You can just ask them. You don't have to take my word for it. There on the left was Eddie Joe Lloyd. He was convicted in 1984 of the murder of a 16-year-old girl in Detroit after he wrote to police with suggestions on how to solve various recent crimes. During several interviews, police fed details of the crime to Mr. Lloyd, who was mentally ill. And they lied to him and convinced this mentally ill man that by confessing, he might help them smoke out the real killer. He later signed a confession. It gave a tape-recorded statement. The jury delivered it less than 1 hour before convicting him on the basis of this confession. There was no other substantial evidence against him. The judge said, I'd hang you if I could, but the death penalty was not available in Michigan at the time. But after almost 2 decades in prison, he was released after DNA evidence proved that this man was innocent and had falsely confessed to a crime that he did not commit. On the right is Earl Washington, who was released from prison just a few years ago here in Virginia after spending 18 years behind bars after being committed of a rape and a murder that we now know he did not commit after having been exonerated by DNA evidence. But this man, Mr. Washington, who was in fact confirmed to be mentally retarded, was able to confess to several crimes at the request of the police, some of which we know he could not have committed. That's the problem. Some of you are thinking to yourself, well, none of this concerns me because I'm not guilty of anything and I never will be and I will never represent people who do. Okay. Let's talk to you people. You innocent folks. Those of you who have never committed a crime and never will, and none of your clients will either. And you wouldn't go out with a girl who did. Fine. You better not talk to the police either, okay? Because number 3, we'll put the guilty behind us. Forget about them. Let's talk about innocent people. Number 3, even if your client is innocent and he denies his guilt and almost entirely tells the truth, odds are good he will easily get carried away and tell some little lie or make some little mistake that will hang him. This is human nature. He gets in there, it's a stressful situation. Imagine a perfectly innocent client. The police say he's been guilty of a murder. He's totally innocent as any one of us. So he goes in there and he meets with the police. He says, I don't know what you're talking about. I was nowhere near there. I didn't kill him. I've never killed anybody. I don't have a gun. I've never had a gun. I've never touched a gun in my life. I was nowhere near Virginia Beach that night. That last line was a lie. He went over the top. He was getting carried away. He got into this groove. He started saying all kinds of things, almost all of them true, that he knew would tend to exculpate himself. Then he got carried away and just said one thing that wasn't true, and unfortunately for him, they can prove that it wasn't true. He may be convicted on that basis alone. But let's say, well, that's not a problem. I'll tell my client only to tell the truth. I've met with him. I know he won't lie to the police. He won't make any mistakes. Okay, that's still no guarantee you won't be getting into trouble. Because even if your client is innocent and only tells the truth and doesn't say anything that is false. Now, already, mind you, we're pretty well nigh into fantasy land. The odds of this being anybody being able to pull this off are really quite slim, no matter how innocent they may be. But just the same, let's pretend. Let's assume he gives the police nothing but the truth, and he is totally innocent. He will always give the police some information that can be used to help convict him. Always. For example, suppose you tell this to the police. Here's what your client tells to the police in his denial of guilt. I don't know what you were talking about. I didn't kill Jones. I don't know who did. I wasn't anywhere near that place. I don't have a gun. I've never owned a gun in my life. I don't even know how to use a gun. Yeah, sure, I never liked the guy, but who did? I wouldn't kill him. I've never hurt anybody in my life, and I would never do such a thing. Let's suppose every word of that is true. 100% of it is true. What will the jury hear at trial? Officer Brook, was there anything about this, your interrogation, your interview with the suspect that made you concerned that he might be the right one? Yes, there was. He confessed to me that he never liked the guy. And then the prosecutor will put that up in big letters, and he'll say, ladies and gentlemen of the jury, it's pretty clear that we've got the right guy here. We've proven that he was in Virginia Beach that night. That's opportunity. And remember, Officer Brook admitted that after extended questioning, he was finally able to get the defendant to admit that he never liked the guy. There's your motive. Motive plus opportunity. Wham, bam. Please. But juries eat it up. And innocent people get convicted this way sometimes. How often? Hopefully not too often, but we know what happens. The United States Supreme Court, don't take my word for this. In Ohio versus Reiner, the Supreme Court of the United States said, quote, one of the Fifth Amendment's basic functions is to protect innocent men who otherwise might be ensnared by ambiguous circumstances. Truthful responses of an innocent witness, as well as those of a wrongdoer, may provide the government with incriminating evidence from the speaker's own mouth. See, it's not just some criminal defense attorney telling you this. Even the Supreme Court says I'm right. Under the facts of that case, by the way, in Ohio versus Reiner, a child tragically was died, apparently the result of shaken baby syndrome. Question was who had shaken this baby to death. And one of the possible suspects was a babysitter who had spent some time with the child that week. The babysitter's story was, I don't know what you're talking about. I did not kill the child. I did not see it happen. I don't know who shook the baby. It was never me. I never did anything of any violent nature to the child. The Ohio State Court said, well, you've got no Fifth Amendment privilege. You, by your own admission, told the investigators that you've done nothing wrong, that you were not involved, so obviously your answers can't incriminate you. The United States Supreme Court reversed and said, well, that's not true. Even though this babysitter denies shaking the child, denies seeing the child die, denies knowing how the child died, this babysitter, by her own admission, apparently the government wanted to ask whether the babysitter might have been with the child at some point that week, during the week prior to the death. And that answer, although by itself not sufficient to convict anybody, could help convict her. That means she's got a Fifth Amendment right to refuse to answer to the question the court held, because it could be used to help convict. Ullman versus United States, the Supreme Court said more than 50 years ago, eerily prophetic. They said too many Americans, even those who should be better advised, view this privilege as a shelter for wrongdoers. They too readily assume that those who invoke it are either guilty of crime or commit perjury in claiming the privilege. That's not true, and it never has been. But it gets worse. Can it get worse? It can. Number 5, even if your client is innocent and only tells the truth and does not tell the police anything incriminating, which, by the way, is almost impossible to pull this off. I mean, imagine talking to the police for 2, 3, 4 hours, and somebody like him can't somehow manage to extract from you something that can be used to help convict you. That'd be extraordinary. I don't think anybody's pulled it off. But even if you could pull it off, there's still a grave chance that his answers can and will be used to crucify you in a court of law if the police, no offense, don't recall his testimony with 100% accuracy. All right, now this brings us back to that pop quiz I warned you about. I told you earlier, remember, it's only been a few minutes, and you weren't up all night, and you weren't the subject of physical duress. You were in the relaxed setting of a classroom here. You were given heads up, advance notice that you would be quizzed on this. Question. We'll start with a couple of easy ones. Remember that article I read you about that? How many people did the police find shot to death last night at that Ocean View apartment that I told you about? A, 1, B, 2, C, 3, D, 4. Who says A? B. C. Get this. Get that with the camera. Move that camera around. Look how many hands we've got there for C. Okay, D. You're all wrong. Everybody who raised their hand, you are the kind of people who should never talk to the police under any circumstances for as long as you live. Why is C not the right answer, by the way? If you know, raise your hand. Yes?
Because you didn't state the cause of death.
Excellent. I didn't say anybody was shot. I didn't say gun, bullet, shooting, firearms. Didn't use any of those words. But I don't blame you if you thought that I did. This is the way the human mind works. We hear things, we fill in details. I said gangland-style slaying. That may or may not imply something, but it doesn't mean that anybody was shot. And that's the problem. You see, even if your client is innocent and only tells the truth and doesn't tell them anything incriminating, and his statement is videotaped, his answers can be used to crucify him. You might say, wait, how can that happen? I insisted, at my insistence, I called the police and I said, look, if you want to talk to my client, you can talk to him, but only if you videotape the whole thing. I don't want there to be any debate between the two of you over what happened. Okay, we'll videotape the whole thing. If the police don't recall their questions with 100% accuracy, he'll be convicted on that statement alone. For example, suppose a man goes to the police, they say, we're investigating a possible murder, a shooting. And the guy says, quote, I don't know who killed Jones, Officer Brook, with all due respect. It wasn't me. I've never touched or fired a gun in my life. How can that help incriminate this man? How can that possibly be used against this man to help convict him? You would think it's inconceivable. But it's as easy as pie. All the officer has to do is read this statement to the jury, and then the prosecutor says, Officer Brook, was there anything about that statement that confused you or surprised you? Yes, there was, he says in a moment of sinister, high drama in the courtroom. And what was that? And then Officer Brook turns to the jurors and he says, I never said anything about a shooting. I said we were investigating a murder. He was the one who brought up a gun. Then you turn to your client, and your client says, that's not true, that's not true. I remember he was the one, or one of the cops, I was with them for 3 hours, one of them in the car said something about, they said they had a witness that I was the shooter. Okay, I'll put you on the stand. And then your client testifies, no, they did tell me shooting. They mentioned it before I said anything about a gun. They brought it up first. And then the police said, that's not true. And now what, it's your word against theirs? For what? You're gambling with your client's life. And police officers can very easily make a mistake like that, just as so many of you did just a few minutes ago, about whether you recalled having heard me say something about somebody actually being shot. Police make mistakes, innocently, inadvertently, unintentionally. Any statement, no matter how exculpatory it may seem on its face, can be used to crucify you all by itself if the police are either willing to lie, not likely, or if they just have an innocent misrecollection of the details as to what they did and did not tell you before you told them what you said. All of these, by the way, all of these problems disappear if you take Justice Jackson's advice and say, thank you very much, officer, but no thanks. How about this one? Here we go. Now, here's the most surprising of all. I've saved the most surprising one for last. Let's suppose you've got the following scenario. Your client's thinking about talking to the police. He acts like, he says, I've got nothing to hide. They think that I killed somebody in Virginia Beach last night. Well, this is what your client tells you in confidence. I don't know who robbed that store. It wasn't me. In fact, I've got a pretty good alibi. I wasn't even in Virginia Beach that night, last night. I was 4 hours away visiting my mother in the Outer Banks. Unfortunately, no, I did not pay for gas with a credit card. I used cash, and so I've got no witnesses that can prove I was there except my word, and of course Mama, for what that's worth, which is nothing. So your client says, so the police want to talk to me, and I want to seem cooperative, so what I'll do is I'll tell them that I was in the Outer Banks last night. Now, there's nothing on its face incriminating about any of that. Let's assume, by the way, that you believe with all your doubt, you've given your client a polygraph exam. You've known him for years, you've been going to the same Bible study for 30 years. You know beyond a shadow of a doubt that he's telling you the truth. And he's not admitting anything. He's not admitting motive. He's not admitting opportunity. He's not admitting that he was there. How on earth could this come back to haunt us? How on earth could this come back to be used against us? Be honest. Raise your hand if you really think the answer to that question is, I can't see how it could possibly be used against me. You're afraid I'll call on you, right? I won't call on you. Well, you're wrong. You're dead wrong. You're always wrong. Everything you say, every time you talk to the police, you will regret it. You see, the problem is, here it is. This is the last point. I think it's almost, even if your client is innocent and only tells the truth and doesn't tell the police anything incriminating, and the entire interview, questions and answers are videotaped, even his truthful answers can be helped to use crucify even an innocent man. If the police, through no fault of theirs, end up in the possession of any evidence, even mistaken and unreliable evidence, that anything your client told them was false, even if in fact it was true. Again, going back to this example from a moment ago. Let's suppose I go ahead and I meet with the police. I think I got nothing to hide. I tell them I was in the Outer Banks last night, officer. How can that be used to convict me? By itself, it cannot. It cannot help at all by itself. But what if I later find out, to my horror, after I put my cards on the table, that they've got a witness, a girl that I went to high school with, an unimpeachable witness. We've never been enemies. She'd have no reason to lie. She swears she thinks she saw me in Virginia Beach last night, a couple of blocks away from that store, about an hour before it was robbed. Now, her testimony by itself isn't going to help the prosecutor. Hell, if she's all they've got, I'll get this case thrown out before trial. But if, like an idiot, I talked to the police and I told them the truth, I told them I was in the Outer Banks, and now, lo and behold, tragically, it turns out they've got a witness, a false, mistaken, confused, but sincere and credible witness who could testify that I was here in Virginia Beach. Now they're likely to get a conviction. Because what they'll do, I've just turned this cop and this woman into the government star witnesses. They'll put Officer Brook on to testify about how my client lied to him about being in the Outer Banks, and then they'll put on this girl who otherwise would have not even helped with their case at all, who will testify, no, that's not true. That was a lie. I saw Mr. Duane's client here in Virginia an hour before the robbery, not so far from the store. By herself, she would not have helped the government in any significant way. But what I have just done, you see, is given them the other part of the puzzle. And now I'm doomed. Just ask them. I close with this example. Here we have a couple of recent celebrity examples of why it is that even people who admit nothing always end up denying it. They always end up regretting it. On the left, we have Martha Stewart. She was the victim, the subject of an extensive government investigation that was looking into the possibility that she was guilty of violations of certain federal laws, securities laws, fraud kinds of things. They couldn't pin that on her, but they were able to get a conviction because she denied it. Talking to the police and later to some of the shareholders, she said, no, it's not true. I was not guilty. So they charged her with lying to federal investigators, and they got a conviction, and she was sentenced to 5 months in prison. Marion Jones on the right side, another person who would still be out today if she had always taken the advice that I'm giving you now. She was asked if she had ever used steroids, a controlled substance. And instead of taking the fifth, she said, no, I never took steroids when I won those Olympic gold medals. Later on, it turned out that she was lying. She worked out a deal. She pled guilty. She admitted that she was lying. And she, over her strenuous, tear-filled objection, even though she has 2 young children, was just recently sentenced to prison for 6 months. The guy who sold her the steroids, the pusher, he got only 4 months. But she got 6 months because she lied to the police and said that she did not do it. You see the problem. Michael Vick, who recently pled guilty, as you know, to these charges with respect to the operation of this dog combat sort of operation at his home. At sentencing, like many other criminal defendants, even though he eventually pled guilty, at sentencing, one of the reasons his sentence was a little harder than it might have otherwise been, the judge said, was because when he initially met with the police, he lied to them and said, I didn't do anything. I didn't do it. I don't know what you're talking about. Even guilty people, but not only guilty people, will always end up regretting talking to the police. So my advice to you, Justice Jackson was right. Any sane, competent lawyer in his right mind will always tell every client under all circumstances, I don't care if you're innocent. I don't care if it's the truth. If it's the truth, great. We'll tell the jury all about it. There'll be time enough to put our cards on the table. But before we get there, I haven't seen yet what the police got. They may have mistaken and confused witnesses who will contradict even the truthful stuff that you say. We have no way to know, no way to predict whether the information that you give them, even if truthful and reliable, will end up unwittingly dispelling our demise. So keep your mouth shut. Don't answer any questions. Let's take the fifth. You'll be glad that you did. God bless America. God bless the Bill of Rights and the geniuses who bequeathed it to us. But now, in fairness, I give equal time, or what's left of equal time, to a police officer who will explain to the extent to which, if any, he agrees or disagrees with anything I've got to say. I have no idea to know what he's going to say, but it'll be interesting. Here, let me give him the microphone. Let's give him a hand. Officer George Brook, the Virginia Beach Police Department.